Jetwalani, what was the page number since we've got that downloaded, airdropped to us? Just tell us the page.
I'm saying Nabam should be
No.
reaffirmed.
The speech.
On last debate.
The debate that you refer to of 85, it's been airdropped to us just now. Just indicate the page, please, for us.
38.
Yes.
What page?
38.
It's been said.
Page 38. Page 38.
38, all right.
Now the second. Now don't bring these various matters.
What's the next point?
The next point is that the fact of 34 MLAs being part of the real recognized Shiv Sena, and this is more substantial, was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelled out that
which part?
I'm reading now at P11.
P11.
P11. Is written.
What happens?
Page 11.
Yes. The second point.
All right.
That the fact of respondent 34 MLAs being part of the real recognized Shiv Sena party was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelled out that they were the real Shiv Sena party. The Deputy Speaker ought inter alia to have desisted from proceeding any further with the disqualification petitions, as it should have been obvious to him that there being now two groups, each claiming to be the So, my lord, the proposition here is that once the claim is made that we are the real Shiv Sena, as opposed to a second group, that we are, in other words, that we have both legislative and organizational majority or heft, the Speaker should desist from proceeding further with a disqualification proceeding pending an adjudication by the ECI, because the Speaker can only go into legislative matters. He cannot go into the organizational situation. In the facts of this case, I may say one more thing. In the facts of this case, all the MLAs in this case, all MLAs, this is part of the party constitution. All MLAs, all MPs of every house are ex officio members of the Pratinidhi Sabha, which is the supreme organizational body of the Shiv Sena. So even if the Speaker in this case were to adopt the twin test, the second one being the organizational issue.
But Mr. Jetwalani, this point Mr. Kaul has also already made, that it is not the case of your side that there was either a split or merger in the political party. The contention was that a rival faction in the Shiv Sena represented the real Shiv Sena.
Real Shiv Sena.
And this has now been found to be true and correct by the subsequent
by the ECI.
Right.
So, my lord, a question was posed.
But therefore, Mr. Kaul has made that point. I don't think you need to.
So the question was posed whether what should be the conduct of the Speaker when such a situation has been pointed out to him.
You are saying
not a split.
You are saying that he has no jurisdiction at all.
He has no jurisdiction. He must submit to the jurisdiction of the ECI. He should desist from pursuing the disqualification proceedings further. Now, my lord, we come to the very important aspect of this matter, which actually takes out the foundation of the applicability of Nabam Rabia. Now, on 24th June 2022, the Deputy Speaker wrote an email to the advocate for the 34 MLAs in response to their notice of 21st June under Article 179C, stating that he could not recognize the email ID from which the notice under 179C was sent. Therefore, he would take no further action until and unless the genuineness or veracity of the said signatures on the letter or the email ID is ascertained. So, in fact, he ignored Nabam Rabia, or ignored it on extremely specious, frivolous grounds, that I could not recognize it and I would wait for verification. That verification was never communicated. So where is Nabam Rabia even involved in this case? You either ignored the dictates of a constitutional bench judgment, or alternatively, you, you ignored it, you rejected it on the basis of extremely flimsy grounds. But in any event, you never acted upon it. That, that notice under 179C never ever obstructed the speaker from what he went on to do, because he contemptuously ignored it on specious grounds. And he disobeyed the then mandate. Nabam Rabia was good law and he ought to have obeyed it. So now this is the real nub of the issue, when the whole case is one of deemed disqualification. And Nabam Rabia is invoked because of that notice under 179C. That you hindered me in my job as speaker by issuing that notice, notwithstanding the fact that Nabam Rabia was good law. In fact, you were not hindered. Factually, you were never hindered, because you tossed my notice into the dustbin. But that's the end of anything further. Your deemed disqualification doesn't apply now.
Right.
Okay. Then, my lord, something very important starts from 25th June. On 25th June, the Deputy Speaker issued summons. Now, my lord, all along, we are told that there are 39 MLAs. Your Lordship has made all those calculations on 39 MLAs. Now, my lord, there's a serious issue here. The Deputy Speaker on 25th June issued summons to 16 MLAs only, informing them that a disqualification petition has been filed against them, which was served along with all annexures only on 16 MLAs. Now, for the first time, they inform us. Remember, this is a very serious issue. First time they inform us is on the 14th of July, when a disqualification petition allegedly dated 27th June. Now, I will point out the pleadings very briefly, or I'll just point out there has never been any reference to a 27th June disqualification petition. Admittedly, it was not served on us. Admittedly. The so-called 27th June petition for disqualification of the remaining 23 MLAs, apart from 16. Lordship remembers there were 39 MLAs. 16 MLAs has been the theme throughout. Even during the hearings in the Supreme Court, which they've cavilled against. The hearing in the Supreme Court on the 29th and the 29th, when they moved the Supreme Court to challenge the governor's decision to call for a floor test, even on that date, the reference was only to 16 MLAs. But in arguments, it is being sought to portray that all 39 MLAs were received disqualification notices. Now, there's a second aspect here, a legal issue. The Lordship turns to page 12. Regarding that notice, regarding the disqualification petition. In every pleading, your Lordships will note that contrary to what is being suggested to your Lordship, in every pleading, there is no mention of the remaining 23 MLAs. That is a matter which has misled this court. I had no idea myself till it was pointed out. I assumed that was always 39 MLAs. But it has throughout been, and there's a reason for that. There's good reason why they only served these disqualification notices and petition to 16. Because they wanted to split the two camps. 16 still made it possible for them to survive a majority on the floor of the House. 39 most certainly didn't. So till the last minute, they only talked about 16. It is only after the new government came into existence, the new speaker was appointed, the new government came into existence, that they referred to 39 MLAs.
We'll just get up for 2 minutes.
Yes, sir.
The Chief Justice of Kenya has to have other meetings, and we'll come back in 2 minutes. So according to you, it was only after the new government came.
For the first time, in a petition, your lordships may note of 14 July, sorry, 8th July, 8th July, yes, which they filed before this court. In that 8th July petition, they said 39 MLAs totally, and they referred to a disqualification petition of 27 June, which nobody was served, and they never referred to any of their earlier pleadings. Now, this whole exercise on 16 MLAs would never have taken your lordships so many days, unless you all wanted to revisit Nabam and all that. But on facts, if they had been fair and said there were only 16 MLAs disqualified at all times and not more, the situation was purely academic. And the reason is malified. Why this division? The reason is malified. You wanted to split the two. You were hoping that you would get back 23 of them and your majority would survive. That is why only 16 MLAs. But when the government fell, that necessity didn't arise. When that government fell, that rationale had gone. Now you wanted to topple the whole government. Now, on this disqualification issue, a second major fault on the part of the speaker. He gives me 2 days to reply. Now, that is very important. A little factual digression is necessary, but it is a little law and a little factual, because this is very important. But this reveals malefice on the part of the speaker in the extreme. Sorry, deputy speaker. Incidentally, there was no speaker for 2 years in Maharashtra.
There was no speaker at all.
Yes.
The deputy.
Now, my lord, within 7 days, please see Rule 73B. It said PDF 129 JC1. Sorry.
What does Rule 73B say?
Yes. Statute compilation.
15 days, right?
7 days.
7 days.
Okay, that's fine. We can go. But that's all I want to point out. Really, it's 7 days. But what is important is, whereas the Maharashtra Assembly rules may be subject to Article 212, which says irregularities of procedure can't be looked at by a court. mere irregularities. If it's a serious irregularity, the latest judgment of Justice Khanvilkar's three-judge bench says that if it involves a question of natural justice in another Maharashtra Assembly case, then it's escalated to the level of a constitutional provision which must be obeyed. And the violation would be 1421, etc. But as far as the disqualification rules are concerned, and when I talk about 7.3b at page 12, this is not part of the assembly rules. This is now part of the disqualification rules. And these are framed under paragraph 8. And my submission is that these rules are mandatory, and any breaches of them by a speaker stroke deputy speaker are not immune from judicial review as per other procedural regulations under 208. Whose effect are diluted by 212. Now, just two paragraphs of two different judgments. Actually, I've set out, but your lordships may just see Kyoto's judgment. PDF 129, judgments compilation 1.
You are referring to these Quixote and Shrimant to say that principles of natural justice is mandatory. There's no dispute on that. Take that point.
Not just that, it's a specific reference to the. I'll just read one paragraph. Your lordships will see what I'm getting at. Para 97 in Kyoto, page 129, PDF 129.
Para 97.
Yes. It's not just the rules pertaining to natural justice. Paragraph 8 rules are all immune from the dilution provided by Article 212. Because these are, I'll tell your lordship, the reasoning comes there. Please see that. That's why I want your lordship to just see it. The reason is contained in paragraph 96. That apart, even after 1986, when the 10th schedule was introduced, the Constitution did not evince any intention to invoke Article 122 or 212 in the conduct of resolution of disputes as to disqualification of members under Articles 191 and 102.1. The very deeming provision implies that that the proceedings of disqualification, the deeming provision says these shall be deemed to be proceedings of the House. The very deeming provision implies that the proceedings of disqualification are in fact not before the House, but only before the Speaker as a specially designated authority. The decision under paragraph 6.1 is not a decision of the House, nor is it subject to the approval of the House. The decision operates independently of the House. A deeming provision cannot, by its creation, transcend its own powers. There is therefore no immunity under Articles 122 and 212 from judicial scrutiny of the decision of the chairman, speaker or chairman exercising power under paragraph 6.1 of the 10th schedule. Now, my lord, 6.1 includes the whole gamut of procedure, starting with the petition for disqualification. The entire gamut of the procedural provision, 6.1, and your lordship may then just see 8.
Para 6.1, right?
It says, subject to the provisions of subparagraph 2 of this paragraph, the chairman or the speaker of a house may make rules for giving effect to the provisions of this schedule, and in particular, and without prejudice to the generality of the foregoing, such rules may provide for, and your lordships may kindly turn to D. D. The procedure for deciding any question referred to in subparagraph 1 of paragraph 6. So when my learned friends talk about the Supreme Court intervening with that notice period, which is prescribed, I'm talking about the 27 decision, which is prescribed under rules framed under 8, i.e. 7(3)(b), the Supreme Court was fully justified. The bench of that day was fully justified. Apart from the fact that it ill behoves a legislative assembly to say that rules framed by it under a constitutional provision can be blindly ignored by it. They're the legislators. If they set that precedent, God save the rest of the country. Now, my lord, even in the latest case of Shriman Patil, I'll just read it from my note, the relevant provision. Even the latest case of Shriman Patil, hello, that was the, I'm now at the bottom of page 12 on D. I'm on D. Even in the latest case of Shriman Patil, this was the, I believe, the Karnataka Assembly case, where time for a reply to a disqualification petition was contrary to the rules of the Karnataka Assembly, the court held in paragraph 190.7 at under. Findings on allegations of not granting specific time in all the above cases are based on the unique facts and circumstances of the case. But actually, after Kyoto's case and the elevation of those rules under paragraph 8, there should never have been any leniency in time given to file a reply to a disqualification notice. You are affecting not only the MLA but his constituency. It should not be understood to mean that the speaker could cut short the hearing period. The speaker should give sufficient opportunity to a member before deciding a disqualification proceeding and ordinarily follow the time limit prescribed in the rules of the legislature. So an exception was carved out in that case, but even so, the principle was reaffirmed that the rules are mandatory. Now, my lord, on the one hand, a disqualification petition is given to us. The speaker ignores Nabam Rabia. 2, he gives me a 2-day instead of a 7-day period. 3, what happens? Now, my lord, kindly see. I'm now on 13, and this is a very important aspect. While those disqualification proceedings are pending, everything is done to prevent me from coming for a hearing. Please see. Now, my lord, I would request your lordships, this is the prelude to my petition before this honorable court on the 27th. This is what actually happened. I did pray for staying of the disqualification proceedings, and in my respectful submission, even had a quia timet, my learned friend Mr. Kaul pointed that out, even if a quia timet injunction had been granted restraining the speaker from pursuing the disqualification proceedings on the ground that a constitutional provision, i.e. 179C, was being ignored, because Nabam Rabia was the law at that time. Right? Even if they had done it, which they didn't do, there would have been nothing wrong with it. What they actually did ultimately was only confine the reliefs granted to police protection, and I'll come to your lordships why, and the time period extension from 7 to 14, from 2 to 12 days. Now, my lord, your lordships will kindly see the threats that were given to me. First, your lordship will kindly see, And this is very important because I couldn't come. They prevented me from dealing with my disqualification application. First, they ignored the 1979C. They chucked it to the dustbin. Secondly, they gave me practically no time, 2 days. And then kindly see the threats that were issued to me. But the first one your lordship may see is 24th June.
Not necessary to read the threats.
You've relied on para 97 of Kyoto. You've also distinguished.
But very important.
We take it that
right.
it was compelling for you to come to
Yes,
the court.
but I'll summarize what those threats were. First of all, my lord, security to I was out of Bombay. Security to my family members was withdrawn. Death threats were being given. Security was withdrawn, and publicly there were pronouncements of the leaders of the Uddhav Thackeray faction that if I come back to Bombay, if I come back to Mumbai, my bodies would be sent straight to a crematorium. That's the nature of threats. In view of that, I had to move the Supreme Court for multifarious reliefs. Out of those, on the 27th, only 2 were granted. There were serious death threats. My lord, one of them, a gentleman called Tanaji Sawant, an MLA, I think he was the minister of the government when the government was united. His office was burnt. It was the most serious situation at that time. And kindly see the response. Now, I don't want to tread on the solicitor's province. But your lordship may just see the letter of the governor at that time. Because, my lord, this shows the kind of information that the government was always receiving, continuously receiving, which ultimately culminated in his decision to call cause of law test. Page 306 PDF.
Sir, it was read and reread. That letter to the governor was read and reread. Correct? So we know that these are the things, correct? Earlier there is a threat, and earlier there was a coalition government, there is a breach. Everything has been read, Mr.
No, this letter pertains to the governor saying the situation is extremely serious.
Correct, that we have.
Please give them security. Look, we're talking now about a speaker and a government that ignores a constitutional mandate. I just want to see what is happening. The thread. You throw out the leader of the legislature party. He gives you a notice fearing disqualification under 179C. You ignore it on completely specious grounds. Then you serve me the next day. You serve me a disqualification petition for 16 MLAs. Divide and rule. When I get that disqualification petition, in the notice you say, reply within 2 days. Contrary to rules, mandatory rules. And finally, you prevent me from coming to Mumbai. I'm entitled to a hearing. You prevent me from coming to Mumbai with death threats and withdrawal of security to my wife and children and burn houses. Conduct of the speaker, therefore, needs to be, my lord, that's the only reason why, notwithstanding that the fact that the factual basis of this case doesn't warrant any legal relook at Navam Beria, because as I said earlier, Navam Beria was never an issue because the notice was never ever acted upon. Notwithstanding that fact, restrictions circumscribing misuse of power by the speaker need to be imposed. And Justice Mishra's judgment in Navam Beria needs to be reaffirmed. So I'm not going into the governor's letter.
What else, Mr.?
Now, under Article 164(2), my learned friend talks about a very high constitutional principle. He elevates the entire conspectus of this case to the evil of defection. The evil of a speaker and a government hell-bent upon power is an even greater evil. But there's a constitutional principle, which your lordship just look at G at page 14. Well, the principle emanates from 164(2), which says that the Council of Ministers are collectively responsible to the Legislative Assembly of the state. Well, what does this mean in practice? It means that when the Council of Ministers collectively lose the support of the majority of the House, they have to step down. So, my lord, much higher than the evil of defection is the principle of majority rule in this country. That is paramount. And the principle of majority rule is to be found, there are judgments on 164(2), is to be found in 164(2). That when you, and that's why the governor is given the right to form a new government headed by that person, not headed by a political party, headed by that person who commands the majority in the House. And he has to ignore, says Rameshwar Prasad and Shivraj Chauhan, which my learned friend Mr. Kaul read out, he has to ignore the fact of any potential disqualification of those members who might support the new government. Now, my lord, at page 15, your lordships may note point 2, H, main heading H, Supreme Court refused to grant stay on floor test. And 2. Well, these two, I'm not going to read these petitions, but they say there are only, on 29 June, and they say that there are only 16 MLAs disqualified. That is the last date on which anything could have affected them. 29 June itself, the petition was for disqualification of 16 MLAs. As I said, the 16 MLAs issue came only on, and till today we don't know the number of that petition. It was allegedly filed before the Deputy Speaker. We do not know the disqualification petition number till today. It is placed before your lordships. What's the page? I'll just give your lordship the page. Never served upon us, but the contention is 39 MLAs all along. Now, just the last three points very briefly. At page 16, JKNL, the floor test was never held. Although there's some limit to causation in the law. To say that Mr. Uddhav Thackeray resigned because of all that went before is, my lord, stretching credulity to the nth degree. He resigned because he knew he had lost the majority. But, my lord, there has to be, this is too remote a cause in law for that to be a consequence of all that happened before. He voluntarily stepped down. Now, my lord, JKL, I'll just read it out quickly and then I conclude. The question of deemed disqualification. There is no such concept as a deemed disqualification. Disqualification has to be actual, and there is a mandated procedure for disqualification proceedings. No, I request your lordship to just indulge me and read Rule 7.7. Page. This is under the disqualification rules, not now under anything else, and not under the assembly rules.
Page 10.
7.7, your lordships were referred earlier. Sorry. The lordships were referred earlier to 7.3b, which was that notice period. Now, 7.7 is the rest of the procedure. Please have a look at it. And for the question of deemed disqualification. Or it's page 12 of the statute compilation volume.
Yes,
must be quite threatening.
huh?
Our presence must be quite threatening.
Acha, you said presence.
Presence.
We have heard patience.
No, no, no.
No, we thought our presence.
We are yet to not follow then.
No, no, it's okay.
7.7.
You were on 7-7.
7.7. The procedure which shall be followed by the speaker for determining any question and the procedure which shall be followed by the committee for the purpose of making a preliminary inquiry under sub-rule 4 shall be, so far as may be, the same as the procedure applicable for the determination by the committee of any question as to breach of privilege of the assembly by a member, and neither the speaker nor the committee shall come to any finding that a member has become subject to disqualification under the 10th schedule without affording a reasonable opportunity to such member to represent his case. There has to be a mandatory hearing in this matter. There cannot be a disqualification without a hearing. Therefore, to talk about a deemed disqualification in the absence of a hearing is to suggest this. Now, my lord, it is suggestive, my submission on this point. A deemed disqualification is suggestive of a contention that the reply of a delinquent MLA and the hearing which he has the right to before the speaker are both empty formalities. It further suggests that the speaker would be necessarily of predetermined mind and partisan bent. To deem disqualification, that means the hearing is an empty formality. Something which a litigant who claims to be upholding lofty ideals and unbiased procedure should be loath to canvass. Then, my lord, equally untenable is the contention of dating back of a disqualification. The judgments in both Rana and Patil are no authority for setting the clock back on all events that took place up to the date of the action which made an MLA liable for defection. A plain reading of those judgments, well, Mr. Kaul has read them out, clearly reveal, see, for example, Rana's case in paragraph 34, that the speaker has to decide. That's all that Rana is authority for. The question of disqualification with reference to the date on which the member voluntarily gives up his membership or defies a whip. It is really a decision ex post facto. The phrase ex post facto does not entail retrospective operation. The argument also completely ignores Articles 189.2 and 191.2 of the Constitution, both of which clearly indicate that an order of disqualification only had retrospective effect. Particularly important, my lords, is 191.2, which says he shall be disqualified when he is disqualified. It has only, disqualification only has prospective effect, not retrospective effect. And lastly, my lord, L, I've already taken this point, so I won't repeat it. But I am deeply grateful for a very patient hearing.
Only a couple of points, Mulad, not to repeat anything. We have, I think, heard Mulad the same thing over time and again. Mulad, if your lordship may just have a note, Mulad, we had filed it, and Mulad, there are brief submissions which are put in the index itself. The points have been flagged, Mulad. First point, Mulad, if your lordship have got that note, Hold on a second.
What aspects will you be dealing with, Mr.
My lord, I am dealing with the 3 or 4 aspects, my lord. One being on Nabam, my lord, very briefly, which is not specifically highlighted. Number 2, my lord,
42 pages.
Quixoto para 122 with relation to 21B. And my lord, the 2 judgments which they have relied upon on the other side to contend, my lord, that there is a permissibility under the constitutional scheme for the court to deal with a disqualification petition directly. And the Karnataka judgment is, my lord, a Bible on not attending meeting constituting a disqualification under 2-1A. Lord, I'm going to, with reference to para 122 of Kyoto, it is only 2 kinds of meetings, my lord, which fall under 2-1B. This, my lord, the first point is, my lord, Nabam. And that, my lord, respectful submission is rule against participation of the speaker till the time, my lord, the removal resolution process is completed. My lord, if your lordship may come to the index, kindly skip the first one. My lord, there is a 1-page index.
Rule against
So
participation.
first point, your lordship may skip on the relevant dates your lordships have considered, noted down. I'm not reading anything from there. The first is rule against participation of the speaker. Kindly come to that at page 5.
Page 5.
And my lord, your lordship may take it, my lord. I'm not reading anything unless, my lord, your lordships have not seen any part. Now, my lord, rule 181 is against participation of the speaker. 179 is removal. Now, my lord, my respectful submission is 181 is founded on the basic principle of conflict of interest. That where you are personally involved or your personal action is or activity is going to be considered, you should remain out. This conflict of interest, my lord, gets elevated to the level of constitutional adjudication. A conflict of interest at the degree, my lord, even in executive functioning, if you have to now test it for a constitutional adjudication, the level would be far higher. So, my lord, there is a dissent, my lord, intra-party dissent which can be shown. And, my lord, the rule against participation of the speaker. And, my lord, this became a question in the constitutional validity challenge which was laid before this honorable court in Kyoto, that intra-party dissent is also a part of the constitutional scheme as well as democracy. How do you create a balance? This, my lord, is laid down, and I made a submission earlier, my lord. The proviso to 179C is the beginning of that rule against participation. Proviso to Article 179C is the commencement of the time duration. I'm sorry.
No.
Yes.
Time duration of commencement of rule of non-participation, and it gets concluded in terms of the main provision of 179C when the removal resolution is considered in the House. Kindly have a look at that, my lord. 181.2 is rule against participation. This is my submission, my lord, based on the conflict of interest and when it is to be tested in the touchstone of the constitutional adjudication, because clause 6 of the 10th schedule is constitutional adjudication by the speaker. Now, my lord, if your lordship may kindly see the next page at my lord, page 6 of my written note, para number 5, which reproduces the relevant portion of 179C.
Yes.
And I'm not going to read it, my lord. My respectful submission is that the proviso is the commencement of that non-participation period to begin, and main proviso to 179C is the conclusion when the removal resolution is taken in the House. Then, my lord, clause 11 from the legislature rule, Maharashtra legislature rules have been reproduced. I'm not reading it. I want to read, my lord, these 3 paragraphs again from Justice Deepak, Honorable Mr. Justice, as your lordship then was not Deepak Mishra's judgment, from para 235 to 238, which are reproduced at page 8 and 9. Now, my lord, when this conflict of interest is raised to the level of constitutional adjudication, and, my lord, the Inter-party dissent is to be kept in mind, on the basis of which the validity of this entire schedule was upheld, 10th schedule was upheld. Kindly come to 235. The purpose of referring to the said article is to highlight the nature of participation of the speaker.
Yes.
I'm sorry, Lord, if I'm missing something.
No, yes.
The purpose of referring to the said article is to highlight the nature of participation of the speaker when the question of his removal arises. It is clearly different under the Constitution. He is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in the first provision, Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. Then 237. The aforesaid reasoning eloquently speaks of the power, position, and the status of the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and it has restricted it to the state, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction, exercise the power of constitutional adjudication, the concept of constitutional adjudication as constitutional value in a parliamentary democracy and constitutional value sustain the democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. The Speaker, when functions as a tribunal, has the jurisdiction, authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purpose of sustenance of democracy, which is a basic feature of the Constitution. Manurula, we are speaking about democracy as opined that democracy in India is a product of rule of law, and it is not only a political philosophy, but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role ascribed to the Speaker under the 10th schedule, it is necessary that Speaker as a tribunal has to have complete detachment and perceivable impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law, and the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally to suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule to the Constitution after intention to remove him from office is moved. The 14 days period being mandatory, the words all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of 10th schedule to sustain the robust vitality of our growing constitution, and it embraces the seminal spirit of rule of law that control all the powers, even the prerogative powers. So, my lord, therefore, this is how, my lord, the court brings in a balancing between these two, my lord, apparently areas which may be in conflict with each other, but your lordships, my lord, brought an interpretation to ensure that it is a smooth functioning. Now, my lord, this is found